Abruzzo, you want log off or shut
Yes,
down?
log off. I'll log back in.
Steve, we don't need to. Is Lee up?
Thank you for the big print, Mr. Abruzzo.
You're welcome, Judge.
It's because of his brow partner. Okay, Miss Mia is here. We're ready to roll. All right, I see the jurors already walking down the hall, which is good news. So let's go through the draft of the instructions. So I like the defense to put on the record if you agree or disagree with every page, okay? And state, obviously, if you have something you want to add, you add it.
Yes, Judge.
So, Mr. Camerino, is this you? Is it Mr. Trevina? Who is it? Okay.
Mr. Trevino, Your Honor.
All right. Introduction, I assume that's okay. Murder in the first degree, statement of charge, okay. Introduction to homicide has first degree murder and the lesser crime of manslaughter. Is anybody asking for manslaughter?
I was wanted to hear a definitive answer from the defense before I removed anything.
Judge, could we, I have not had that opportunity to
Okay,
have that.
all right, well, we won't take it out yet.
Thank you, Judge.
And you know, it's obviously, manslaughter, I believe, is the only Category 1 lesser, so that if either side requests it, I will give it. On the Category 2s, I usually give anything the defense asks. I'm a little more careful with giving one that the state asks if the defense objects, okay?
Certainly, Judge.
So, and I just want to be really certain, you know, and nobody knows what the jury's decision is going to be. It is a very high-risk move anytime a defense lawyer or the state attorney decides on a first-degree murder that they don't want any lessers. It is not my decision. I want to make sure Ms. Mee has appeared to understand everything about these proceedings from the beginning. The only time I had any question about it was when she had said something to Dr. Poorman about the 25-year maximum. And then, of course, it turned out that that was, as you had suspected, Mr. Trevina, just a misstatement by her based on some idea with lessers. Now, since nobody's alleging that she had the firearm, if she was convicted of the lesser included offense of manslaughter, I'm just putting this all on the record so we have no question later that all this was placed on the record.
Thank you, Judge.
So I don't think it can even be enhanced, correct?
That's correct.
Okay. So manslaughter is a maximum 15 years. Like unlike for the co-defendant, we had to have a separate finding of manslaughter, not of the 1020 life, but of the reclassification, because it could be enhanced due to the firearm. So since the state's evidence is not that she had the firearm, manslaughter is a 15-year felony, max. Now, that doesn't mean she should ask for it, but I just don't want to be getting any mail later that said, I didn't understand. So, and that one is a Category 1 that somebody's entitled to. So, like I said, if there's any other, so at this point, Mr. Trevina, are there any Category 2s that you were thinking of requesting?
None.
Okay. So, at some point today, and sooner rather than later, on a break, I want you to have the conversation, and obviously you'll have to have one, if you maybe do them both at the same time, probably, about whether or not she wishes to testify. We won't have Mr. Labruzzo change the instructions yet, and then we'll do a colloquy that includes both the decision about whether or not to testify and the decision about the lessers, okay?
Thank you.
All right, so then, we know we have to get back to that. Then there's justifiable and excusable. Those look okay, Mr. Trevino?
Yes, Your Honor, those
Okay.
appear to be standards.
Yeah. Okay, then there's a couple places where hopefully we'll note to take out lesser included crime if we need to. Okay, look at the first-degree felony murder instruction, please. Defense?
And Judge, I spoke to Mr. Camarino a minute ago about an issue. We're discussing it as well, so I know they're going to raise an issue. If we could just have a minute to discuss it.
All right.
All right. Judge, I spoke with Mr. Camarino this morning about element number 3.
Yeah.
I initially told him I did not agree, but upon further reflection and reading it, I would agree. State is going to remove the first part of element number 3 where it says.
I wondered about that.
Yeah.
Okay, so what you'll take out was Jennifer Mee was the person who actually killed Shannon Griffin.
Yes, Judge.
And so what number 3 will read is Shannon Griffin was killed by a person other than Jennifer Mee, but both Jennifer Mee and the person who killed Shannon Griffin were principals in the commission of robbery.
Yes.
All right, I think that makes much more sense.
If we could have a moment, Judge, I'm trying to look at the standard to see how it tracks the
I
standard.
think it's an or, but I'll look at mine too. How are we doing this morning, Deputy Birch? Thank you.
I also believe just the caption it's a minor issue, but
Well, we'll change anything we need to.
in the standard, it's felony murder dash first degree.
I just made it consistent with, I thought the indictment said murder in the first degree.
But I think the jury instructions supersede.
I bet you the jurors will neither know nor care, so
I can correct it if the court, if that makes everyone happy. I don't think.
go ahead.
All right.
Okay, let me find that.
Judge, element number 2, the state has proposed the instruction as the death occurred as a consequence of and while Jennifer Mee was engaged in or attempting the commission of a robbery.
Mm-hmm.
I'm looking at the standard, and it says give 2A, 2B, or 2C as applicable. The first says the death occurred as a consequence of and while the defendant was engaged in the commission of the crime alleged. And I'm assuming that's robbery that they're alleging. Then B says the death occurred as a consequence of and while the defendant was attempting to commit the crime alleged. And I'm assuming that's where they're getting the attempted robbery. And then the third, which I believe we would all agree doesn't apply, deals with escaping from the scene.
Right. Well, I think that's how we did it with, probably how we did it with the co-defendant. I've done it that way all the time, and both sets of language are in the indictment. If they weren't, it was while engaged in the perpetration of or in an attempt to perpetrate the crime of robbery.
Does the attempt offense act as a sufficient predicate for felony murder? If someone is accused of attempted robbery and a death occurs during an attempted robbery, is that, and I'm asking this question, not stating it, is that indeed a predicate offense for felony murder? Because when I look at the felony murder statute,
Yep. When a human being, wait. Seven 782.042, no, 041A, which is what it's charged under, when 1A2, unlawful killing of a human being when committed by a person engaged in the perpetration of or in the attempt to perpetrate.
So it would apply then?
Yes, sir.
All right. No objection based on
Okay.
that?
All right. So you'll take out that one line.
Is there, if there's something I need to change, or?
No,
No,
Okay,
except for that one line you said you were going to take out.
correct,
I did.
Okay, perfect.
and reverse the,
Okay, now, robbery. Is this the new one, the old one? What is this?
Judge, I did a little research on it. The only difference is that it removed attempt as a category 2 lesser. That's the change to the instruction. It's nothing substantive. It is only in
Okay.
what is a category 2 lesser.
Okay,
It's no longer a category 2 attempt for robbery. And it doesn't change any of the elements of the crime.
all right, thank you. I understand what you said. Okay, look at the robbery instruction, Mr. Trevino, please. Witness here?
En route.
Excellent.
I'm at the robbery section, Your Honor.
Right. I was hoping you were. I'm waiting to hear from you about it.
It appears to follow the standard. I don't see any deviation.
Okay, attempt?
I see where I need to change a he to a she.
paragraph 2.
Oh, yeah, okay. And then abandoned her attempt in the next paragraph. See that second line?
Yes, Judge.
And then her criminal purpose. We won't catch them all, but the ones we catch are good.
Well, I did a search to try to get as many as
Good for you.
possible, but clearly it didn't work.
I usually miss a tremendous number of them, so I'm sure you got more than I did. You still looking at attempt?
I am, Judge. In the attempt to commit crime in the standard, unless there's been a statutory change since my book, says that to prove the crime of attempt to commit,
Is that one of the new ones? I didn't think it was. Mr. LaBruzo?
I'm sorry, Judge?
The attempt isn't one of the new
No,
ones.
Judge, it's not.
Okay.
so the first paragraph, the introductory paragraph says the state must prove the following two elements beyond a reasonable doubt. I think you left off the words two elements.
No, actually I didn't, because there, in the standard instruction, what Mr. Trevina is correct. When using attempt is either charged or a lesser included offense. To the paragraph or the sentence that I included is indicated when you're using,
For
when it's
felony.
necessary to define attempt as an element of another crime, such as felony murder, as provided in the text.
I see that, Mr. LaRusso, thank you.
Sorry.
Okay, so attempt is good?
Just one more moment, Your Honor. That's fine, Judge.
Okay, great. Next, principal, 3.5A. That's not a new one either, correct?
No, it's not, Judge.
Okay, that looks like exactly the standard to me. Take the scissors, Cheryl. Thank you.
That does track the standard, Your Honor.
Thank you. All right, now, let's go on and assume for a minute we're gonna have manslaughter. Okay, so the lesser, that looks okay, I think. And then we'll need to read the manslaughter. It's easier to take it out than it is to put it in later.
Yes.
All right. 7.7, and that's not one of the new ones either, correct? I mean, it's new recently, new and troubled, but it's not new 2 weeks ago.
No.
But he didn't know how she
Wait till she's over. Manslaughter is a lesser, we're just reviewing it to make sure it comports with the standard instruction. It does appear to track the standard.
Right, and he does the manslaughter by act, so we're not involving the negligence or anything.
Manslaughter. Yep.
Okay. All right. Aggravation of a felony by carrying a firearm should come out.
Yes, Judge.
Okay, so I'm just going to physically rip that page out.
No objection.
Plea of not guilty, reasonable doubt, and burden of proof. Imagine you'd like that.
Yes, sir.
Weighing the evidence. Now, are they both in here, or how do we do it?
The
Okay,
new weighing the evidence is the last 2 or 3 pages of the instruction.
all right.
New weighing the evidence includes defendant testifying as well as expert witness, and has some additional paragraphs that may or may not apply. I included them.
Right. I understand.
Show me the other one. Okay, that's this incorporate.
Oh, is it in this one?
Oh, maybe that's it. Yeah.
So this is the new one.
That's the old one.
Okay, so go to the last 3 pages, Mr. Trevina.
I'm looking at them now, Judge, thank you.
Mm-hmm. expert witnesses are like other witnesses with one exception. Page 2, if you count paragraph 9 as a paragraph and 10 as a paragraph, it's paragraph 5. Expert witnesses are like other witnesses with one, O-N-E.
Oh, I'm sorry.
That's all right.
This may seem splitting hairs, but
Feel free.
technically, and correct me if I'm wrong, I may have missed it, but I don't believe the state actually had the court find or declare any of their presumed experts to be experts in any particular field or area.
Right, because the law has changed so that they're not supposed to do that. And if they start to do that, I have them come to the bench, because the more current law is that the judge is not supposed to announce that they're an expert in front of the jury. So if you challenge it, you can do individual voir dire still. Sometimes they come to the bench and say, do you mind if I proceed? So I think they followed the law completely, the most current law.
But my question would be to the court, and I haven't read that case recently, is that retroactive to the time of the offense, or is that at the time of instruction?
It's been that way for a while. So it's not, it's new for people like me that have been around 35 years. It was another thing I had to get adjusted to. But it is not new like 2 weeks ago or 6 months ago. It's been around for a while, and it's the more current method. So,
Which is why I think they have the instruction the way it's written, to let the jury decide.
right.
Understood, Judge.
Okay. All right. So keep reading that. So as you'll see on the last page of that instruction, if is in there about the defendant testifying. If she doesn't, then there's still the separate instruction on that. Now, someplace I was reading that was new. Did you look at that? I didn't think it was new.
Not see
There
that.
normally would be 2 paragraphs that were
No, that's the separate defendant is not testifying, but that's not included in weighing the evidence. It makes no sense, but they don't ask me my opinion. So this is now in the new weighing the evidence, which came into effect 2 weeks ago. The defendant testifying is put right in weighing the evidence, telling you to evaluate their testimony like other witnesses. If the defendant does not testify, we either still have exactly the old one or very comparable to the old one.
Judge, the state's going to be asking ultimately for the paragraph after expert witness to be removed. I don't think there's been any evidence as of yet to say that anyone helped her commit the crime that would be testifying.
Okay, hold on. Oh, I see what you're saying, as of yet, so, where am I going? I need this. I need this. Okay, so under defendant not testifying, I'm just looking ahead, Mr. Labruzzo, while they're talking about 3.9.
But no, that would come
I'm confused. What would be different?
I get already,
Can you see what was amended?
I'm looking to see, Judge.
I don't see one word is different. I've compared the book, which was the old one, and the Supreme Court website, which is the new one, and your paper, and all three are exactly the same word for word. Maybe they're just saying amended because it stays separate and doesn't go in weighing the evidence like the other one. Maybe it's some weird little thing.
Judge, you know what it...
Okay, so are you talking about that last big
Oh, Judge, I
paragraph?
think I know what it is.
What?
Not that it, let me just give me 1 second to confirm my thought. Yes, it is, the old instruction was 3.9D, it now becomes
DA?
3.9A.
Yeah, DA.
That's all they did.
Okay.
I'll just take out the,
It's 3.9 DA, like duh.
no, they removed, it was previously.
Oh, I see what you're
They
saying.
just,
I see what you're saying.
I'm just gonna take away the A, B, C, and Ds.
Very good,
That way it's easier for all of us.
very good. Okay, lawyers. 3.9, Mr. Trevina. Do you want the new one or the old one? First,
The new one.
okay. All right, then,
Take out.
okay, so then that last paragraph, I'm not going to take it out now. We'll see what the evidence is. Okay? Mr. Abruzzo?
I'm sorry, Judge?
That paragraph, you want it out of the new 3.9, you must consider the testimony of some witnesses with more caution?
Yes,
I'm not
Judge.
going to take it out now. We'll see what the evidence is.
Yes, Judge.
Okay,
If I can just have a moment to kind of catch up with the court before we move on.
yep. Okay, so I'm not moving on, I'm just confirming with Mr. Trevina. You want us to take out the old 3.9, Mr. Trevina, and use the new, correct?
Correct, Your
That takes out the old 3.9A, which was experts, the old 3.9C, which is Jennifer Me testifying. We would then leave in the packet the defendant not testifying, and then we'll pick which one like we always do later. Sound good so far?
Yes, Your Honor.
Okay. And the way, assume, except for the defendant testify, not testify, you want the new 3.9 like Mr. Labruzzo has put it in here. You guys have read it.
Yes, Your Honor.
Okay. Mr. Labruzzo, may I now talk about Jennifer Me's statements?
Yes.
All right. So going back to earlier in the book, Mr. Trevina, after Jennifer Me not testifying, the next one is Jennifer Me's statements. That appears to be the standard one to me. And was that just changed by renumbering to B, I think?
Yes, Judge.
I think you were right about that.
I'm sorry, Judge, I lost where we were at.
All right. Go, you are at the back of the book. Go back earlier in the book to right after Jennifer Me not testifying.
I have that.
Okay, so if she doesn't testify, that's what we use. Then, the next page is the old 3.9E. It's been renumbered as 3.9B, but you're going to just take that out. But anyway, so do you want Okay,
There
so,
is another grammatical,
okay, what do you want changed on that?
second paragraph, whether anyone had promised him anything in order to get him to make it.
This is under Jennifer Mee's statements.
Yes, the one that says number 2.
Oh, sorry.
Yeah, and
Nope.
number 1, too, says and threaten in order to get him to make it.
Okay,
I got it.
very good. Thank you. All right, then rules for deliberation, and this is the old one, right?
Yes,
Yes.
Judge. Is there a new one?
Okay, cautionary instruction, verdict. So we'll need to change that if she doesn't want any lessers. And they read, the verdict must be in writing, so it's the necessary form, Mr. Labruzzo, a verdict has been prepared for you in 3.12 verdict. Then it reads, is how I like to do it, as follows. And then we'll have and then take out read verdict forms, I know that.
So Judge, you want me just to say instead of they are as follows, they read, it reads as follows?
Yeah. Because there's only one form, so it isn't a they. All right, so we'll have the clerk do 2 verdict forms, one including murder in the first degree as charged, lesser manslaughter, not guilty, one including murder in first degree, and not guilty. Okay, Madam Clerk, there's no other, you're very lucky, no other interrogatories. Okay, and submitting case to jury. Any problem with any of the rest of that, Mr. Trevina? It appears to be all the old standards.
It does, Judge.
Okay.
No objection.
All right, so Mr. Labruzzo, I appreciate in your spare time this week that you have done this for us, and we'll know later a few things, and as always, I'll have somebody who is assisting me in the back make all the copies once we get a final one, so you all don't have to. All right,
Judge, we do have a defense instruction that we, the
okay, where's that?
court to consider, if I may have a moment. 3.6L, at least under the numbering I have, which is independent act.
Book. You guys have that in front of you?
I do, Judge.
I do.
I remember there's some case law on this, but I don't remember what it says.
Judge, I can provide the court with some case law. State has researched this as well, providing a copy to the defense as well. For the record, it's 2 cases. We have Thomas v. State located at 787 Southern 2nd, 27, and Perez v. State located at 711 Southern 2nd, 1215. One is a second DCA case, one is a third DCA case. But they do discuss the independent act instruction as it relates to felony murder.
same case?
No, he said it was different.
Oh, is it? Okay.
Mine's a third easy.
Think you...
Do you have any case law? Mr. Trevina?
Judge, we do not, Your Honor.
Okay. Okay, this is what I suggest we do on this. Go ahead and just put it in on a separate page, and I will give them time to look for case law on it. And it appears that, and I can let people argue about it a little bit later, but I'm going to give them, I mean, if they're asking for it, it makes sense. There was some case law to support the request. I remembered there was something, that was sort of a prerequisite before you got it. So, we'll just put it in the draft as a separate page. The defense can look for case law to support it. We can argue that later. Okay?
Nope, Judge, if I just, there's another case that I will pull, just to let you guys know if you're going to be pulling cases. 18 Southern 3rd, 562, Cannon v. State also addresses this issue. Judge, I have no problem putting it in to the draft. My issue is that there are a number of fill-in-the-blank type questions, and I can't foresee which
Right.
fill-in-the-blanks
Just
they
put,
want.
just put the form in there
Yes,
for
ma'am.
now, okay? And, I'll be happy to review any case law on the point. So that's just another thing we have to get done before we finalize our instructions. Okay, can we do the JOA? And then, so the defense, I mean, the state, have you reviewed the exhibits? Is everything
Judge,
in
we
that
did.
you wanted? So you've rested,
We are going to
rest when they come in?
Yes,
So we're going to have a 5-minute comfort break before they come in. Now, did you have a motion for me, defense?
Yes, Judge, are you speaking to our motion for judgment?
Start that now, Your Honor?
Well, don't we usually do it before we put on the defense case? Yes?
Normally, the state rests on the record before we,
We will rest now on the record with the court. We'll rest when they come back in.
Very good. Okay, I'm
thank
listening.
you, state. Two major points for the motion for judgment of acquittal, Your Honor. The first deals with a quasi-technical issue. If you take a look at the indictment that was filed in this case, the indictment states that in the county of Pinellas and state of Florida, on the 23rd day of October, in the year of our Lord, 2010, in the county and state aforesaid unlawfully, while engaged in the perpetration of, or in an attempt to perpetrate, the crime of robbery, did shoot Chiron Griffin with a firearm, and as a consequence thereof, Chiron Griffin died. And during the commission of the offense, Jennifer Mee and LaRon Rayford and Lamont Newton actually possessed and discharged a firearm. And as a result of the discharge, death or great bodily harm was inflicted upon any person, contrary to chapter, and then there's the statutory citation. The problem that the defense has with the wording of the indictment is this is a very factually specific indictment that has alleged that Jennifer Mee possessed and discharged a firearm, among other things. The state is obviously arguing felony murder, but the indictment and the language of the indictment that the state chose to use in this case is first-degree premeditated murder with a reference to the robbery. It does not clearly show that this is a felony murder type charge. And by using the specific wording that Ms. Mee possessed and discharged a firearm, when we've just discussed that issue with regard to jury instructions, she never possessed a firearm, there's no evidence to that effect, that is essentially a fatal defect or variance in their charging document, and that based upon the significance of that distinction between felony murder and first-degree murder, premeditated murder, that the court should either confine the state's argument to the allegations in the charging document, or in the alternative, grant the judgment of acquittal.
Okay.
You want me to move on to the second grant?
Well, let's go ahead and handle that first.
Okay.
Mr. LaBruzzo?
Judge, there are a few things I think the defense overlooked in presenting that argument. One, that this is an indictment that charges 3 co-defendants, and the language for which he's putting emphasis on is language that the state is required to allege and put all 3 on notice, as it's required by the law if the state were to seek an enhancement based on a possession or a discharge. He also failed to eliminate for the court that the state alleged Florida Statute 777.011, which is the Florida principal statute, a law which we just agreed to being included in the discussion as part of the instructions, that, along with the other language, sufficiently puts Ms. Mee on notice of what we are arguing and what the law is. I think to say that there is any defect in this case is not correct. I have no case law in front of me that says this is defective. I think the state has adequately placed all 3 defendants on notice of what the crime is, when it occurred, and put them on notice of all the statutes involved and any enhancement that the state could seek at the time of trial.
Okay. Well, as you all recall, all 3 of these people were indicted in one indictment, which you remember I complained about because that makes it so difficult for the clerk to record everything correctly, and Ms. Mee is defendant A. And part of the reason they did that is they wanted all 3 people to have one trial, and we spent hours and hours reviewing transcripts, and Miss Olney went through and tried to take out anything she could find that would cause a problem for trying all 3 defendants together. And ultimately, I ruled in favor of the defense lawyers, saying that the state couldn't get it cleaned up enough, and I permitted you each to have a trial, which of course gave me 3 times the work, but I thought it was following the law. So they have correctly indicted these people on felony murder. I don't read this indictment and think it's anything but felony murder. It put everybody on notice as to felony murder from the very beginning. No one has been alleging that Miss Mee actually held the firearm during the commission of the crime, or as far as I don't know of any evidence that she held it at any other time. But they very carefully did put in the principal language. I don't think the indictment is defective in any way, and the defendant was on notice. And a JOA should not be granted on that ground. Okay, now part 2, please, Mr. Trevina.
Thank you, Your Honor. Part 2 is the state and the court, I'm sure, are abundantly aware of the multitude of cases that stand for the proposition that if the state's case or theory of their case is not inconsistent with any reasonable hypothesis of innocence, that the court, under those limited circumstances, should indeed exercise her authority and grant a judgment of acquittal. You'll recall the magic question was asked of Detective Warzinski late yesterday. At the very end, I believe it was the last question I asked in my cross-examination. And the question was, is there, and I'm paraphrasing, but basically, you cannot rule out, Detective, that the version that Miss Mee gave in her first interview is accurate. And he conceded that based on the totality of this case, he indeed could not rule that out. Well, that is synonymous with saying that he cannot rule out a plausible hypothesis of innocence that we have proffered in the case. The failure of the state to contradict, which is their burden, to contradict every reasonable hypothesis of innocence of the defendant, me, gives this court the authority, the discretion, and I would respectfully suggest the obligation to not let this case go to the jury based upon the testimony you've heard. And as a sub-argument to the reasonable hypothesis of innocence, I would also suggest that the sufficiency of evidence is certainly of concern in this case. But when you have the lead detective concede he can't rule out a hypothesis of innocence, which was quite reasonable, I think it's incumbent upon the court to make that very difficult decision to grant a JOA. And we would so respectfully request, Your Honor.
Thank you. Mr. Labruzzo?
Judge,
Or Ms. Olney? Okay.
I believe that there was sufficient evidence in the testimony that the state has presented in this case to include Ms. Mee's own admission to the detectives as well as to her mother that she participated in the robbery. I believe that Detective Warzinski did make a comment that he couldn't rule that out. When he first was interviewing her, he had no basis to rule that out. I don't agree with the statement that Mr. Trevina has provided to the court about what Detective Warzinski's testimony was, and I would ask the court to rely on that evidence.
Okay. The motion for judgment of acquittal is denied. All the evidence is to be taken in the light most favorable to the state, and I don't in any way think Detective Warzinski's testimony was diminished by that. He's actually not supposed to really be giving opinions on those things, but you asked him his opinions on various stories. And he continually went back to the fact that her later statement was consistent with her statement with her mother and with the other evidence in the case. Okay, so that is denied. Now we'll take a 5-minute break and bring in the jury. Is the defense ready with your first witness?
No, Judge, she is present, but if I could ask for 10 minutes after if you want to bring the jury in and they rest, and then just give us a possible 10 minutes.
Okay.
And Judge, this is the witness, Ms. Chiron, as you're well aware.
I am.
There have been some accusations about her prostitution. We would like that proffered before the court, because we believe there's no basis to be asking any question that would be an attempt to character assassinate her based on no other evidence other than the question.
Okay. So do you want me to bring her in and do that now? Do you want me to give the jury a break? What are you asking?
I think
They've been sitting there since
We could come in and
9:15.
rest, and then you could give the jury a break. That way they understand what's going on, maybe a little bit more.
All right.
Also, Your Honor, just so the state's on notice, Detective Warzinski will be called again by the defense. Is he in the building?
We have not, this is the first we've heard that you wanted to call him, so we have not seen him. The court instructed him that he would be on standby. I have not spoken to him this morning.
Is there a way you can communicate?
Sure.
Thank you.
All right. Thank you. Okay, so let's bring in the jury.
Judge, the jurors are present and seated in the jury box.
Good morning. I know you were here all right on time. Sorry you had to wait. Raise your right hands, please. Do you swear or affirm to tell the truth? Thank you. Please raise your hand if you got any information regarding this case during the recess. I see no hands. State?
Judge, at this time, the people of the state of Florida rest its case against Jennifer May.
All right, thank you. All right, there are matters I need to take up outside of your hearing, so I'm going to give you just about a little more than a 20-minute break, so you can go down and get a coffee, or if you smoke cigarettes, or whatever it is, so that I'm not just keeping you locked in that room for the next 23 minutes. We'll have you back at 20 minutes to 11. Please do not discuss the case among yourselves or with anyone else. Thank you.
Judge, the jurors are in uniform.
All right. So, Mr. Labruzzo, have you been able to ask someone to contact the detective?
I was planning on calling his cell, but
All right. Okay.
I'll do
We'll
that.
make sure.
Very good. All right. And so, Mr. Trevina, you can talk to your witness, and what else are you going to do on this break? Are you going to have time to talk to your client about certain issues?
I hope I do, Judge.
All right. Okay, we'll be back at 20 minutes of.
All rise. Court is recessed for 20 minutes according to the clock. Clock. Stand by 1 minute. Yep.
Oh, perfect, great. Oh, that was working. You didn't even have to put it in the rotation. I was going to do that. Walk there.
I'm actually gonna go down. I'm just gonna go down. I'm actually just gonna sit. I'm gonna go about here and come back. I need to work.
No, so I think the second one. Thanks, Chris.
And of course, you have the evidence out?
No.
all of those factors could be explained as a reasonable hypothesis of innocence, that knowing already from previous hearings, Judge, that Ms. Chiron has said that there was essentially strategy meetings, discussions on how to respond to questions by the police, to go as far as to create, I believe she said at the time, multiple scenarios that would end up providing mitigation for her boyfriend, who she was pregnant by at the time, and that there was motive for thinking that because Mr. Laron Rayford was mentally retarded, handicapped, that he, and again, these are explanations by Ms. Chiron and depositions and hearings, that might indicate that he should be the fall guy because this would be more mitigating to her. There was discussions that Miss Me should take the blame because she was young. She had no prior criminal history whatsoever, and that because she was young and had no prior history.
Okay, so how is it relevant, other than you're going to say, well, there was a condom, so it must mean it was Ms. Chiron because Ms. Chiron is involved occasionally in sexual situations in her workplace. Is that what you're trying to tell me is the relevance?
In part, yes.
Okay. Would you like to say anything?
Yeah, I don't think that, I think it's way more prejudicial than it is probative of anything that's being discussed here. And it's improper.
I have two thoughts. One is, you're entitled to present your defense. Two is, you need to be careful about opening the door to things that otherwise might not come in. And three is, you're going to be bound by the same rules of evidence as other people. I will ask something briefly about sex at the workplace based on what you've put on the record about the condom. It should be brief. It should not be the emphasis. And all witnesses in here should be treated with dignity. All right, that's my ruling. We're
Thank you.
done. Bring in the jury.
Very good.
And video. I do, yeah. Please. See if
Judge, the jurors on press proceeded to jury conference.
Thank you. Mr. Trevina, you may call your first witness.
Thank you, Your Honor. Detective Warzinski.
Dave Warzinski.
So we'll put him under oath again because it's a new day.
Yes, ma'am.
You do swear or affirm that testimony you're about to give will be the truth, the whole truth, nothing but the truth of God. Thank you.
Step this way, have a seat. You're gonna lie.
Whenever you're ready, Mr. Trevina.
Thank you. Good morning, Detective.
Morning, sir.
Just a few matters. As lead detective in this case, did you employ the same type of normal investigative techniques that you would apply in any case?
Yes, sir.
And would that include, for example, reviewing jail phone calls and video visitations?
They were requested. I didn't view them.
Who requested them?
It's standard that we'll request them. I know the state attorney's office also requests them, but I did not personally review them.
Any reason you didn't go through them to ascertain what might be of evidentiary value?
The only reason I can give you as to why I did not watch, there were voluminous ones from all three defendants, was just time.
Okay. Would it be fair to say that in the 3 years that Miss Mee was at the Pinellas County Jail, she had a voluminous number of phone calls that she made from the jail?
I can assume that.
Okay. And based upon what feedback you got, is it a technician you send, or is it, do you know physically how it happens, how these calls?
For video visitation, I contact the sheriff's office, and if they have a visitor, they'll burn copies of it. For phone records, usually we'll go out in person and make logs of what they and download them ourselves.
So just so the jury has an understanding, if you're not an attorney or a law enforcement official, how do you go visit an inmate if you're a family member or friend?
I guess you make an appointment. I don't know. I've never done a visitation myself.
Okay. And once that visitation occurs, it occurs by video cameras, similar to like Skype, where you have a handset headphone, but the person isn't near you. They're still at the jail, correct?
I understand so.
Okay. And in this case, there were video visitations that you collected but never reviewed.
Yes, sir.
But they were provided to the state?
I don't know if they received a copy or not. I know I have a copy.
You do have a copy?
The ones that were sent to me, yes, sir.
Okay. How many of those do you have?
I don't know, sir.
Do you have them with you?
No, sir.
How high a stack of discs are we talking about?
It would be an estimation on my point. Some are CDs. They might have multiple visits on them. I don't know.
Another technique is to utilize someone who resides in the same population pod to
Judge, I'm going to object at this point.
Okay, approach the bench.
if any admissions have been made during conversations at the jail, that type of thing.
I've spoken to inmates who wanted to give information in reference to cases that they know are being prosecuted, yes.
Okay. And then my next question is, in this case, did you employ any such technique?
I did not.
That was it.
Judge, my question is that, is it the practice of the St. Petersburg Police Department to employ
That's the word.
inmates?
No.
Do that?
I don't utilize anyone by money or means. That's information that they're providing to us. I at no time have ever gone and sent someone in to try to gather information.
So, Judge, my objection is this.
I understand. Well, maybe I should let you say it. Go ahead.
Judge, it's just that there's this assertion that somehow the police would then employ an inmate to snitch on another inmate. What that just is not factually correct. It didn't happen in this case, and nor it's not what they do.
Okay?
Did I use the word employ? If I
Yes,
did,
sir, you did.
I'm sorry, Judge. I used it in the sense not of monetary, because of course I know that.
But the jury wouldn't.
I'll say utilize, and not employ.
So you just want to know if sometimes police use snitches in the jail. Is that what you're asking?
Correct, but I won't use the term snitch.
All right, Mr. Labruzzo, anything else to say?
Judge, other than there's no evidence of that, this is purely fishing as to what happened in this case.
Well, there is no evidence. I think he's just trying to say it's like there was no fingerprint.
Right.
So if there was one, of course, the defense lawyer would be saying how terrible, but I understand. That's what he's trying to say. So bring him back, please.
Thank you, Judge.
Water?
Tower. Rodney Tower. He's calling.
I thought you said something else.
Judge, the jurors are present, seated in jury box.
Thank you very much. Mr. Trevina, you may continue.
Thank you, Judge. Detective, as I was asking you, one of the investigative techniques that's used by law enforcement is to utilize inmates who may be in the same population or pod as a defendant to see if there has been any conversations or discussions that would be considered admissions by that person, correct?
That's correct.
Okay, and in the 3 years that Miss Mee has been at the jail, no inmate has, to your knowledge, stepped forth and offered testimony, information, anything of that nature, correct?
That's correct.
I believe that's all I have. If I just may have one moment. That's all I have.
Thank you. Any cross?
Just briefly, Judge. Detective Warzinski, you don't yourself, or law enforcement doesn't go to the jail and solicit people that are in the same pods with other individuals that you are investigating to try to get them to testify against those individuals. Is that accurate?
That's correct. We do not.
Occasionally, an inmate will contact you looking for maybe some favoritism in their case with information they have about another defendant. Is that correct?
Yes, ma'am.
I have nothing further.
Okay. Step down, please. You didn't have any other questions, right?
No, Your Honor.
Okay, very good. Thank you. You may call your next witness, Mr. Trevina.
Thank you, Judge. And he may be released from defense perspective,
I'd
Judge.
ask that you remain, Judge.
Stand by, please, detective. Did you call your witness?
Oh, I'm sorry, Jennifer Chiron.
So why don't we swear her in out here? Right. Very good, thank you.
You do swear or affirm that testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God. Thank you.
Whenever you're ready, Mr. Trevina.
Thank you, Judge. Good morning, ma'am.
Morning.
Please state your full legal name for the record.
Jennifer Ann Chiron,
And what is your date of birth?
April 16th, 1989,
And where do you reside?
at 2550 Dartmouth Avenue.
Directing your attention back to October 23rd of 2010, just about 3 years ago. Excuse me. Where were you residing at that time?
At 610 Fifth Avenue North.
Okay, and who were you residing with at that location?
My boyfriend at the time, Laron Rayford, Jennifer, me, and Lamont Newton.
And that address, I'm sorry, 610 was it?
Yes.
Fifth Avenue? Was that a single-story home? Is that a apartment?
It was a three-story apartment complex.
Three-story apartment complex. And where was the apartment that you were residing in, first, second, or third?
On the second floor.
How long had you known Laron Rayford at that point in time, going back to 2010?
Maybe a couple months.
Okay. And you were dating as a couple?
Yes,
And in fact, you were carrying his child?
yes.
At the time, you were employed at a spa facility, correct?
Correct.
And as part of that employment, not to offend, but there were sex acts that would be performed by you in exchange for money.
Yes,
And that provided you a pretty decent living, as I understand.
yeah, what I did there with the whole dominatrix and fetish thing was paid extremely well.
Okay. So money was not a problem for you.
Not at all.
Now, at this point in time, how long had you known Jennifer Mee?
She had moved in with me 3 weeks prior to this happening, about, so
Okay,
3
and
weeks.
When she moved in, was that the first time that you actually knew her?
Yes.
Okay. Did she move in with anyone else?
Yeah, her and Lamont Newton moved in together.
Okay. And was Lamont Newton a boyfriend, to your knowledge, of Jennifer Mee?
Yes, they were dating to my knowledge.
So essentially, you have two couples residing in the same apartment.
Correct.
Now, directing your attention back to again, October 23rd, 2010. That was a Saturday. Tell the jury, if you would, about what time you came home from work.
It would have been a little bit after 9 because I had closed down the shop and took about 10, 15 minutes on the bus, so maybe quarter after 9,
Okay.
around there.
PM, correct?
Correct.
All right. So 9:15, we understand that's an estimate. You arrived back at your apartment after work?
Yes.
Okay. Who's present when you arrive back?
Lamont, LaRon, and Jennifer.
Okay. Were they doing anything?
We were all getting ready to leave, so the boys were getting dressed, Jen was dressed up, and I was about to get in a shower and get dressed also to go out.
Okay. And what were the plans for that Saturday night?
We were going to go see Paranormal Activity at the IMAX Theater downtown.
So that was a movie that was then playing?
Yes.
Then. All right. And it was the intention of all four of you to go see this movie?
Correct.
And you indicated both, in addition to Miss Me, both Mr. Rayford and Mr. Newton were wearing nice clothes.
Yeah, we were dressed, yes.
Not suits or anything,
No,
but
you know.
nice attire for going out and seeing a movie.
Well, Miss Me was in a dress, and LaRon, they were in clothes that had, you know, pretty decent labels on them, but weren't too out of the average of what, you know, we'd normally wear around.
Okay. Were there any pets in this apartment complex?
Yeah, we had I'm sorry, pets?
Pets, yes.
Yeah, we had a dog and a cat.
Okay. And did they roam freely throughout the apartment?
Yes, they did.
Would there be occasions that you and Jennifer would walk the dog?
Yeah, we'd take the dog out front, and we lived on a second story for.
In that 3-week time period, did you really ever have a chance to get to know Miss Me?
Yeah, we went out on a few occasions. We went shopping and got clothes and hung out and did the whole little girl thing. My little sister used to come over and hang out with us, so we used to walk around the neighborhood and we'd spend time with my little sister, and so we did spend some time, you know. We were the two girls staying in a house.
Okay. And you had no particular dislike for her, correct?
No, not at all.
Now, you had knowledge that Miss Me received a monthly government check.
You approach the bench. Send the jury back to the jury room.
Put your note and on your chair.
John said to Don Hall, talking about more than this.
Yeah, well, he interviewed her.
Yeah.
That's what I'm saying. That's what you were.
Yeah, all right, he answered it anyway.
Oh, okay,
So
oh, okay. No.
that was only going to be impeachment.
No, just call him up and give him. That's what I mean.
Oh, I'm sorry, yeah.
But it's not
No,
transcript.
that's not the one I'm talking about. I'm talking about statements that look like that. Ones that were recorded. Recorded interviews.
Trevina, what were you going to ask, please?
You were aware that Jennifer Me received a monthly government check, correct?
Yes,
And do you recall approximately how much that was?
around $675-ish.
Okay. So she had money as well.
Yeah.
Judge, our objection is to the labeling it a government check. You can say that she received money. I don't think you need to know.
Okay, so your objection is to government check,
Yes, Judge.
not to 675, not to anything about her having money.
Well-
I'm just trying to be clear what your objection is.
If she could just explain, how do you know it was 675?
Well, after the incident happened, when my brother was moving out, he moved all my stuff, and there was the printouts that the check comes out on, and it had the amounts both her and LaRon had. So afterwards, like, going through all the stuff from the apartment,
So you later learned that that's what the check amount was?
yes.
I think, did you know that at the time of the,
I knew she was getting a check, and they were supposed to be getting an apartment of their own, but I didn't know prior to seeing the paperwork afterwards.
and now I think the way it's been phrased to the jury is that she had knowledge of this at the time of the robbery, which is the reason Mr. Trevino is offering it, and I don't think that to be true.
I strongly disagree, unless my hearing's failing me. She said she knew that she was getting money, but didn't know the source of it until she saw the checks afterward. Is that correct, Ms. Chiron?
Yeah, I've seen, like, everybody's paperwork, like, there was a social security card, and there was a bunch of different paperwork, so after we had moved, my brother moved out all the stuff, I went through everything.
Thank you.
So when did you first learn Miss Me had a government check?
It was after I had been released from jail, and probably 6-7 months after the incident.
Okay, and when did you first learn how much money she was getting?
At the time, I seen the paperwork a
Okay,
few months
so you knew
afterwards.
none of that at the time that this occurred?
No, I knew she was getting money, and they were supposed to be getting an apartment with it, but not where from, well, I thought it was a check, you know, I knew she got money at the beginning of the month, and
Okay. Anybody else have anything they want to say?
Well, I assume now, Judge, if she knows she got money at the beginning of the month, that Miss Me has told her that she got money at the beginning of the month, and that's hearsay and clearly not admissible.
Well, you can ask her questions to find out how she knows, if somebody wants to. I shouldn't be asking all the questions here. Sure.
Do you, how did you know that Miss Me was receiving a check at the beginning of the month?
initially, LaRon told me that she would have money at the beginning of the month, and that her and Lamont would be moving into their own apartment.
Is that when she was moving in with you?
Yes.
Nothing further.
Okay. So here I am. Does anybody have anything to say?
Judge, I think it's clearly hearsay at this point.
It is?
It's not being offered for the truth of the matter asserted, Your Honor. It's,
Okay. That always makes me smile when the state says it. It always makes me smile when the defense says it. That never makes a lot of sense to me. Well, probably on a rare occasion. Okay. So, is there any part of this that the state does not have an objection to, yes or no?
No.
Yes,
Okay. So I'll sustain the hearsay objection. All right, bring them back. So you know when I say sustain, it means don't answer it?
Yes.
And you know when I say overrule, that
Then
it
it
means
means to
do
answer
answer
it,
it?
yes.
Very good. Thank you.
Judge, the jurors are present and seated in the jury box.
Thank you. Thank you for your patience with us, ladies and gentlemen. Mr. Trevino, you may continue.
Thank you, Your Honor. Now, Ms. Chiron, you've indicated that you were dressed, ready to go to a movie. Do you remember when that movie was scheduled to start?
It was after, I know it was supposed to be after 10.
Okay. And where did you say it was you were going to?
It was Baywalk, and we were going to watch it in the IMAX theater.
All right. Now, at some point, Mr. Rayford and Mr. Newton indicated that they were going to or needed to go somewhere.
Judge, I'm going to object as to hearsay.
Sustained?
Your observations of those two gentlemen, you were able to see that they were preparing to leave the apartment?
Yes.
Okay. And did they, in fact, leave the apartment?
Yeah, they got a phone call and they left.
Okay. Was it Mr. Rayford that got the phone call?
Yeah, Miss Me had called my cell phone and spoke to, I can't be 100% whether it was Lamont or LaRon, but LaRon was the one holding my phone. I don't know eventually who spoke to Miss Me, but
Okay.
LaRon did have the phone when,
And Miss Me, at this point in time, was still in the apartment?
no, she had left. She left the apartment first and then called the boys, Lamont and LaRon, and they left after getting the phone call from her.
Okay. But you don't know that was her calling?
Well, when I seen her number, I gave LaRon the phone.
Okay. And then after that phone call, the two gentlemen left?
Yes.
Now, prior to that point, did you ever hear Miss Me indicate that she was going to participate in any way in any kind of a robbery?
No, not that night, not before anything happened, no.
Okay. Having socialized with Miss Me, would you agree that she tends to be more quiet and reserved?
Yes, she's more relaxed and withdrawn than, say, someone outgoing like myself would be.
Do you remember what time Jennifer left the apartment?
It was within a few minutes of me getting home from work.
Okay. And it was still, based on your communications with her, the intent that you were going to go to the movies?
Well, yeah, when I asked her, when I seen the boys grab the backpack out the closet, and I think it was the closet, and I seen, you know what I'm saying, it was a little early for, like, us to be putting on shoes and stuff like that. I asked what they were going to do, and she said she was going to go get some money.
Who is she when you say?
Jennifer, me.
She didn't say she was going to go rob someone, did
No.
she? And you had no indication or concern that there was some crime to take place, correct?
I didn't give it a second thought to, you know, they were going to go handle something before we went out.
Okay. If I may refer to one of the state's exhibits, Your Honor, bear with me a moment. Your Honor, for the record, I am referring to State's Exhibit number 25, previously stipulated into evidence. Miss Me, this is the blue New Jersey bag that you're referring to,
Yes.
correct? Okay, and you recognize that, correct?
Yes.
That was not in Miss Me's possession when she left, correct?
No.
That was taken by who?
I don't remember, one of the boys had it. I don't exactly remember who walked outside the door with it, but Lamont or Laurent,
Did you know what was inside that bag?
no, not at the time.
Okay. Were you aware at any time up to this point, in the 3 weeks or so that you were residing together, that anyone had a firearm?
Yes.
Okay. Do you remember what kind of firearm it was?
It was a .38 revolver.
Okay. And are you somewhat familiar with guns?
Yes.
How did you first become aware of the presence of that weapon?
Lamont and Laurent came home one night, and I was hanging out front, and they came home with a backpack. They had said that Lamont's brother had got shot at.
Hearsay as to what was
Sustained?
Okay. Let's talk about only those things that you actually observed. You were aware there was a firearm. Did you ever put your eyes on that firearm?
Yes.
Did you ever handle that firearm?
Yes.
Do you know if it was a loaded gun when you saw it?
It was unloaded at the time, but further down the road in the house, it was loaded.
Okay. And who loaded that gun?
I did at one point, Laurent did at one point. Me, Laurent, and Lamont all took turns handling the gun at some point.
Did you all participate in, like, target shooting?
There was a point in time where me and Lamont were going to go in the backyard and shoot it off a few times. Laurent didn't want to have anything to do with it, but
Okay.
we were going to take it out back of the apartment complex, and then something ended up coming up. And
So getting back to the evening and night of October 23rd, you start by making plans for a movie. Jennifer leaves the apartment. Has she dressed at that point?
yeah, she was wearing a dress and was putting on her shoes when I came in.
Okay. She's not carrying any book bag.
No, the only thing she had was Laurent's cell phone.
Okay. And approximately how much later before Mr. Rayford and Mr. Newton left?
Maybe 5 minutes, if that. It wasn't very long.
Okay. And after the three of them have now left, you're alone in the apartment with the pets,
Yes.
correct? All right. What's the next thing that happens in time that evening?
The next, Jen came running up the stairs saying that she had heard gunshots. And then I asked her where Laurent and Lamont were, and she said that she didn't know. So I went to putting back on my clothes from work and trying to put my shoes on to go see where the boys were.
Okay. So you immediately went into a rush mode to try to locate the two gentlemen.
Correct.
And we're talking about, with respect to Mr. Rayford, this is the father of your child to be born. This is your boyfriend. This is someone you care about deeply.
Yes, and his best friend, who I called Bro also, and
That would have been Lamont?
yes.
So you had known Lamont for a long time as well?
I had met Lamont right around the same time I met Laurent.
Okay. So, like a fiance and a best friend to you?
Yeah, like a bigger brother figure and a fiance. Correct.
Okay. So Miss Me comes back to the apartment. Is she crying?
She was extremely disturbed, like she was out of breath. You could tell she had been running, and she was just like in a panicked state.
Did she look horrified or?
She was panicked about hearing the gunshots. It seemed like overwhelmed by that at the time.
Okay. And then when you went out of the apartment to look for Mr. Rayford and Mr. Newton, did Miss Mee remain behind in the apartment?
Yeah, she stayed in the apartment. I didn't even make it fully down the flight of stairs before Laron with Mr. Rayford was coming up the stairs.
Okay. Tell us what you observed about Mr. Rayford as he was coming up the stairs.
We got back in the apartment, and I had noticed he was missing his shoes, and he was extremely upset, screaming that
What type of shoes did he have when he left?
he had just put on some Jordan flip-flop slides real quick before he had left.
All right.
And he was also in a panicked mode, screaming that bro, meaning Lamont, and had been shot and was dead. He was under the impression that Lamont was,
So he told you, Mr. Rayford, that Lamont Newton was shot.
correct.
Okay. And I'm sure that probably caused you then to become upset.
Yeah, it was a really highly emotional time for the three of us. Ron actually punched a hole in the wall, and
That was going to ask next. Did you then, when Laron meets you coming up the stairwell, did you, the two of you, then go back and re-enter the apartment?
yeah, we went into the apartment. He had locked the deadbolt on the front door, and he had hit the wall and was basically yelling that bro was dead, bro was dead.
Okay. And then what happened next in time?
A few, not maybe a minute or two, there was a banging at the door. I opened the door, and it was Mr. Newton Lamont.
And because you had deadbolted it, he couldn't just walk into the
No, he
apartment?
couldn't.
Okay. Describe for the jury, if you would, what Mr. Newton appeared, how he looked.
He was disheveled, like, like, again, you could tell he had been running. He was bleeding. He had cuts and bumps on him.
Did it appear that he had been in some sort of fight or scuffle?
Yeah, it looked like when both the boys came in and you took a good look at them, it looked like both of them had gotten pretty physical at some point with someone. It looked like they kind of had their butts handed to them.
So they, by your observations, were the losing party of any fight that may have occurred?
Well, they were pretty scuffed up.
Okay. And you indicated there was bleeding?
Yes.
What next happens as Mr. Newton comes in? Now all four of you are back in the
Yeah,
apartment.
he took a couple steps in the apartment and collapsed on the floor, and so I started checking him over to see, if he was bleeding out from a gunshot wound or had any major.
Did he explain to you what?
Object as to hearsay as to what he said.
Sustained?
Did you learn in your discussions with Mr. Newton why he believed that he may have been shot?
Good, I'm going to inject a hearsay.
Sustained?
All right. Do you all remain in that apartment the remainder of that night, or do you leave somewhere?
We leave.
Okay, before we get to that, you had said that Jennifer Mee had returned to the apartment how quickly from the point she left?
It might have been like 10, 15 minutes,
If that? And that next was Mr. Newton, and that was about how many minutes after?
Well, next it was LaRon.
Oh, I'm sorry, Laron?
Yeah, that was maybe a minute or, he came back a couple minutes after. I don't want to say particularly, it was less than 5 minutes, more than a minute.
Okay, that's fine. When you don't know exactly, your best estimate is fine, and if you don't know, it's perfectly acceptable to say, I don't know. So, and then after Mr. Rayford arrived, how long before Mr. Newton?
A couple minutes.
A couple more minutes.
Yes.
Would you say that all of this occurred within a 30-minute span from the point that Jennifer left to the point that Mr. Newton, who was the last to return?
Yeah, less than 30 minutes probably.
Okay. Did you hear at any time in that 30-minute period any gunfire?
No,
Did you hear any police sirens?
no,
Okay. Did you hear anything unusual?
no, besides everyone freaking out and the running up and down the stairs, no.
Okay. Did you notice after they had returned that the boys, referring to Mr. Rayford and Mr. Newton, you call them the boys, correct?
Correct.
That the boys did not have with them certain items that they had when they left?
Yes,
For example, did you notice that the book bag, the one, State's Exhibit number 15, I believe it was, 25, I'm sorry, State's Exhibit number 25, the book bag I showed you, that was not with them?
yeah, that was not there. LaRon was missing a shoe or two. I think there was a hat missing. One of them had left with a hat and didn't come back. There was articles.
Was this like a black baseball cap with some kind of emblem on it?
It was a fitted cap. I'm not sure what color it was at the time, or
So none of those items were on their person when they returned?
no.
Did they bring with them things that you had not previously seen before?
And not at that moment. I didn't see anything until later.
Okay.
I noticed that they had brought back things, but not until we had left that apartment.
How long did it take to vacate the apartment after everyone had returned?
Basically, it was more kind of waiting on a ride to show up, but maybe a half hour, if that also.
Had you learned at this point that someone had been shot
Yes,
and had been left in a yard?
I knew that someone had been shot, yes.
And when you learned that, before you all left to go somewhere else, was it your intention to go to try to find that person?
I was trying to go back to where it happened, yes.
Okay. And what was your reason for wanting to go back to, let's call it the crime scene?
To retrieve items that the boys had left behind, including the gun, anything that would have put them there. And then, I mean, obviously after LaRon saying that that Lamont was shot, and then Lamont coming in and saying that someone
I'm
else.
objecting to what Lamont said and these individuals said.
Sustained.
Did you make it to the crime scene?
No.
Okay. Was it simply you were unable to locate it?
No, they wouldn't describe where it was. Lamont had told me that he didn't know where the gun was.
What these individuals say as it relates to.
Sustained?
I know it's hard, but try to limit your answers to not what someone told you verbally, but things you observed,
Okay.
to avoid any hearsay objections. So when did you leave to relocate?
Lamont and LaRon had a friend show up, and as soon as he showed up, we left. So probably about a half hour.
And do you know who that individual was that showed up?
I'd never met him before.
Okay. And when he arrived, did all of you then get into his vehicle?
We did.
Okay. And then where did you go?
To some apartments down in South St. Pete.
Okay. And why that location in particular?
I believe Lamont had family down there he was going to see, or something to that nature.
Okay. Was there a taxi ride involved at some point?
Yeah, I wasn't comfortable with the ride. Like, I'd never met the gentleman before, and I wasn't comfortable being in the car with him, so I had called up one of my friends, and we had went to my girlfriend's house. So I had got a ride there. I didn't want the gentleman going to my girlfriend's house or knowing exactly where we were going to be.
And what was your girlfriend's name?
Portia Grimmage?
Portia Grimmage? Okay. And did you arrive at Portia's residence?
Yeah,
Okay, and that was by taxi now, correct?
correct.
Who ordered the taxi and who was the taxi driver?
I had a friend, Ray, who used to drive us to and from work and to run our errands, so I had called him up.
And he did show apparently?
Yes.
And then did drive you to Portia's residence?
Yes.
Had anyone at that point in time brought anything with them? Change of clothes, toothbrush, anything at all that, for a stayover?
Yeah, me and LaRon, I was packing up stuff for me and LaRon, and I told Jen and Lamont to grab an outfit also, that we were gonna obviously need change of clothes if we were leaving, and
Did you have concerns that with you not being able to clean up the scene, that police may soon be involved in the case?
well, like I said before, me and everyone in the house had pretty much messed with the gun, and so I was trying to obviously get that back because I wasn't sure if my fingerprints were on it, and, you know, I knew that all of us had handled it, so.
Miss Mead, did you ever actually see her touch the
No,
gun?
I'm referring
To you,
Me and-
yourself?
Lamont and LaRon.
Okay. So you were worried your DNA or prints might show up on that weapon?
That and the boys, and so,
So you're trying to help out your fiance and your best friend as well?
yes.
Okay. Now, when you reach Miss Grimmage's residence, Portia, did you have the initial conversation with her? I mean,
Yes, I had called her on the phone, and I had stayed at her house before. I actually ended up moving in at a point after this happened. So I had called her up and was like, is it okay if I bring the boys over? I told her that we had got into an argument with my landlord. We kind of needed somewhere to stay for the night while everything calmed down. And so she was going to her boyfriend's house or out to work or something like that, so.
Did she seem to believe your cover story that it was just relating to an issue with the landlord?
I didn't think it was an issue. She, you know, told us to be more than welcome to help ourselves anything in the house. She told me basically, like, to...
My house is your house kind of
Yeah.
thing? Gotcha. Now, all four of you, plus Miss Grimmage, are now in the apartment?
No, she was on her way out as we were going in.
Okay.
So basically, I grabbed the house key off of her because I didn't have the key to that apartment on me. And so I grabbed her house key. And
Was she planning on coming back that evening?
No.
What was taking her away? Was she already have plans to be somewhere?
Yeah, she was going out. Like I said, I don't remember if she was going out to the club to work or if she was going out for drinks with friends or to the boyfriend's house. I know later on she ended up at the boyfriend's house.
Very good. So now the four of you are in Portia's apartment. Is this when discussions started to occur about who should say what when the police came knocking?
Judge, I'm objecting that calls for hearsay.
Ask the question again. Don't answer it till I rule.
I'm trying to recollect the exact phrase I used. You were aware, or I'm sorry, you were at this point engaging in discussions, without telling me what they were, about what to say if the police came knocking.
Again, I object.
Sustained.
All right, let me rephrase. When you're in the apartment, the four of you are talking, correct?
It was sporadic. Lamont and LaRon were.
Judge, I'm not to say.
Right, there's not a question for you to answer yet, ma'am.
Okay.
Were you going to say, though, that Lamont and LaRon were talking to each other?
Yeah, there was points where it was me and LaRon talking. It was points where it was Lamont and LaRon talking.
Okay. Now, without telling me the content of the conversations, because that would be hearsay, can you tell me that the subject matter, based on your direct knowledge being there, concerned coming up with various cover stories if the police were to investigate?
Judge, I'd object. I think the subject matter is here.
Sustained.
Your Honor, may we approach?
Mm-hmm.
At some point, the police did approach you, was it, initially?
Yes.
Okay. And when in time did that occur?
The next morning.
Okay. Did you remain at the apartment with the 3 others throughout the night?
No, I went to work the next day like everything was okay.
All right. Leaving Mr. Rayford, Mr. Newton, and Miss Me in the apartment?
Correct.
All right. Over the course of that evening, were you prepared, if necessary, were you prepared to give a statement to the police?
She can answer yes or no.
Not at that time.
Okay. At some point, based upon all that had occurred, were you prepared to give a statement to the police?
Yeah, the next day.
Okay. When you're first, I'm going to back up a little bit and we'll get to that more. When you're first approached by law enforcement, when and where does that occur?
I was at work and it was a phone call. First it was Laron's uncle, and then it was detectives investigating the case.
Did you end up hanging up on one of the detectives?
Yes, I hung up. I took the battery out of my phone. After calling a ride back to the apartment, I bought a prepaid cell phone and left work and went back to the apartment where everyone was at.
So that's when the track phone was purchased?
Yes.
And why a track phone?
Well, just because it was a number not associated with anyone. It was a clean phone.
Okay. And then you go back to Ms. Grimmage's residence?
Correct.
All right. What's the next contact that you have that involves law enforcement?
Miss and me and myself were coming back from a store, and I had an unmarked detective's car pull in front of me and jump out of the car with a face sheet, which is a piece of paper with my picture on it and information. They read me my rights and put me in the back of the car, and were trying to ask me questions about where everybody was and what had happened. And
Okay, let's slow down. When and where did this second contact come?
it was a block away from the apartment.
Okay, and it was the next day,
Yes.
which, correct me if I'm wrong, this incident occurred Saturday, October 23rd. The phone call you received would have been on Sunday, the 24th?
The next day, yeah. if it
Okay,
was
and then the
Saturday,
physical contact that you just described would have been Monday, the 25th, correct?
No, it would have been the day that I got off the phone with the detective.
Oh, so the same day?
Yeah, a little bit later in the afternoon.
They came to Ms. Grimmage's
Yes.
apartment. And I believe you indicated that you and Jennifer Mee were walking?
Yes,
You had went to the store?
correct.
Were you carrying groceries?
T-shirts, change of boxers, socks, just cigarettes, blunts, things like that.
I'm going to stop you for a moment, and I'm going to go back since you mentioned clothing. Was there a point in time at the other apartment that you all shared, the one at 615 Fifth?
610.
610 Fifth Avenue? There were clothes in a bathtub in that residence, and there was a bleach bottle in that bathtub. Do you recall that?
Yes.
And what were you trying to accomplish with that?
Well, as soon as, Lamont came in, I had stripped him down looking to make sure he wasn't shot, and there wasn't any blood coming from anywhere I couldn't see. And basically, the whole point of the bleaching the clothes in the bathtub with the water and stuff was to get rid of any physical evidence that may have been on the clothes.
Okay. Did you already have the bleach, or did you have to go purchase it?
I already had the bleach. We would sometimes put the puppy in the bathroom if everyone in the house was going to be gone, and so we used that for cleaning.
All right. So moving forward again to the later that Sunday when the police car, you indicated it was an unmarked type car,
Yeah, it was an unmarked.
pulls up and they immediately arrest you and put you in
Well,
handcuffs?
they pulled out the picture, piece of paper they had with my picture and information on it, and once they seen that it was me, yeah, they automatically read me my rights and sat me in the back of the cop car.
And when they did read you your rights, you invoked your right to remain silent and requested counsel, correct?
Yeah, immediately I asked for a lawyer.
Okay. What did they do with you at that point?
The whole good cop, bad cop routine. I had one telling me that I was going to jail for 5 to 10 years for accessory after the fact and hindering and obstruction and throwing all kind of terms and different charges at me. And then I had another detective come actually sit in the back seat with me, and he told me he was just trying to locate LaRon and, tried taking a softer approach with me to try and see if he could get me to tell him where LaRon was.
Okay. At that point, did you still maintain your silence?
Yes.
Were you then transported to the St. Petersburg Police Department?
I was.
And were you still remaining in handcuffs at that point in time?
And no, they had took the handcuffs off. The detective that was trying to take a softer approach with me came and sat down in the back seat, and he took the cuffs off and asked me if I would voluntarily go down to the station.
So when he's taking the softer approach, is he informing you, you don't need an...
Objecting to hearsay.
Sustained.
This softer approach left you comfortable that you were going to be treated as a witness and not as a defendant, correct?
No. No kind of approach from the police makes me comfortable at all.
Okay. Where did Miss Me go while this is happening with you?
And she was standing off by a tree in one of the neighbor's yards speaking with another detective.
Okay. Did you ever see her try to run or anything like that? from
No.
the police? Okay. Was she put in handcuffs as well?
No, for the entire time I was there, she was speaking with a detective, looked like she was cooperating, and they were having an intense back and forth conversation.
Were you then driven to the police station?
Yes.
Okay. Were there any stops between Ms. Grimmage's residence and the police station?
Not that I can recall.
All right. Once at the police station, what do you observe? Where are you brought to?
It was, I think it was a burglary or something. It said burglary interrogation or burglary/robbery interrogation room, and they sat me down in that room.
Okay. And in that room, were you alone or was there someone with you?
There was an officer, I believe, with me the whole time in that room.
Would that be a uniformed officer? Or
There was a uniformed officer with me at all times, and then in between, detectives would come in and out.
Okay. What time roughly are we talking about now when you're at the police station and...
I
this
have
going on?
no idea whatsoever.
Do you know if it was dark out yet?
It was probably mid-afternoon when they took me down to the station, so at some point it did turn dark, but when I first showed up, it wasn't.
Apparently you were there for quite some time.
I was.
Did you see Miss Me there at the station?
At some point, yes.
Okay. Was she just walked past you? Did she enter the room? Kind of describe that context.
Detective brought her into the room where I was.
Intentionally to be with you?
Yes. He allowed her to speak to me,
Okay.
and
So, was it one of the case detectives in this case that...
I believe so, yes.
And then after you spoke to Miss Me, did they separate you again at that point?
Yes.
Did they bring LaRon Rayford or Lamont Newton by you at any time?
I seen LaRon walk past to go to the bathroom after quite some time of being there.
Okay. But prior to that, they didn't allow you to come in contact with LaRon?
No.
And what about Lamont Newton, same thing?
No.
Okay. Did you ever see Lamont?
When they were arresting everyone, yes, I see. He was off in another corner of the police station. but
Now, when you're in the police station and you've described everything that you've observed, the detective had come in with Miss Me, let you two talk. Do they then request a formal interview of you?
yeah, they asked to receive my statement at that time.
All right. You had already invoked your right to remain silent. Is this the point where they instructed you that
There's the hearsay.
Sustained.
you had previously invoked your right to remain silent, correct?
Yes.
But now they were going to question you anyway.
Yeah, they were asking for me to make a statement, correct?
Okay. Was a promise made to you that,
Calling hearsay.
can we approach, Judd?
Yep.
Judge, the jurors are now here in court.
Thank you. All right, Mr. Trevina.
Were you, when the detective went to re-interview you, were you explained that you didn't need a lawyer, you didn't need to invoke Miranda because you were being treated as a witness, not as a defendant?
At some point, I think that they did say that they were just trying to find who the shooter was and that they weren't looking to charge me formally with anything.
That's exactly what I wanted.
Okay.
And Judge, I think what the detectives say to her is hearsay. And it's
Sustained. Thank you. It's proffered into the record. Let's bring them back. If they're not ready, just let us know how much time they need, okay? Well, as soon as they're out, they can come back. Did you need water or anything?
No, I'm okay, thank you.
You're welcome.
Judge, the jurors are present and seated in their dock.
Thank you, ma'am. Mr. Trevino, you may continue.
Thank you, Your Honor. Suffice to say that ultimately you were persuaded to go ahead and give a statement.
Correct.
And you, in fact, did give an initial statement, correct?
I did.
And then you gave a second statement that was materially different.
Judge, I'm objecting as to Officer hearsay as to the contents of the statement.
Sustained.
Your Honor, I'm not asking for the contents.
Approach the bench.
Thank you. I'm sorry. So you gave an initial statement, then you gave a subsequent statement, and ultimately you went home.
Correct.
Did you ever see any of the items that belong to the victim in the case, Shannon Griffin?
I did after the fact, prior to leaving to the store where I was met by the detectives and took in downtown. When I had got home from work, in between that time frame, I had seen that there was a cell phone and a wallet, work ID on Portia's bed in the bedroom.
Okay. And did you look through that, look through the driver's license, the cards, the Walmart ID, that type of thing?
Yeah, they were lying in the bed, and I picked them up and was curious. And
So it wouldn't be unusual for your fingerprints to show up on any of those items, correct?
no, it wouldn't be unusual.
If I may have a moment, Your Honor?
Mm-hmm.
No further questions at this time.
Thank you.
Ms. Strong.
Russ?
Good afternoon.
Afternoon.
So it's your testimony today that you worked all day on October 23rd, is that correct?
Open to close, ma'am.
What time did you get there?
It would have been before 9 o'clock till a little bit after 9.
12-hour day.
Yes.
You took a bus home?
Yes.
Took you approximately 15 minutes to get home?
Yeah, 10 to 15 minutes.
And where I believe you also testified that prior to Jennifer leaving, she was talking or having conversations with another person on that phone.
Yes, she was on LaRon's phone, and she had received a phone call, and that's what prompted her to leave the apartment.
And they were gone approximately 10 to 15 minutes.
Yeah, not long at all.
And she came back upset.
Yes,
Then LaRon came back.
yes,
Then Lamont came back.
yes,
She said she heard gunshots.
yes,
And after all three of them came back, you wanted to go back to where this crime occurred.
correct.
You didn't know where it occurred.
No,
You hadn't been to that crime scene.
no,
And no one told you where it occurred.
no. I didn't know specifically where it was until I was released, and I actually seen the news set up there, and they were taping the crime scene. That's why I actually physically seen where this had took place.
Had you ever been in that crime scene before?
No,
Do you know where it is now?
yes.
Did you know it was behind a deserted house?
Well, I knew it was at a deserted house. I didn't find out it was behind the house for quite some time.
That was after the fact.
Yes.
So you'd never been back behind that house?
No, ma'am.
After they all get back, you all decide to leave the apartment.
Yes.
You change clothes?
At that time, yes, I changed into some, I was wearing a pretty short dress, and so I changed out of the dress into, I believe, a pair of pants or something, and grabbed up some clothes, yes.
And LaRon changed clothes?
Yes.
And Lamont and Jen went into the bathroom?
Yeah. There, we were in and out the bathroom. The boys were bleeding and stuff like that, so it was pretty chaotic. It was,
And you're not telling this jury that you poured bleach in that bathtub on those clothes, are you?
no.
Jennifer poured the bleach on the clothes.
I can't say that for 100% fact.
Jennifer and Lamont were in the bathroom.
Yeah,
You smelled a strong odor of bleach coming from that bathroom.
yes.
So Jennifer or Lamont poured bleach on the clothes,
LaRon was in the bathroom at some point, too. I can't,
but you didn't pour bleach on the
No.
clothes.
I may have come up with the idea, I think but
Just
physically.
listen, just ask my questions.
Your Honor, I would ask that the witness be permitted to respond in full.
My rule in here always is that a person can answer the question yes or no and give a very short explanation. Okay, next question, please.
The next day, you go back to work.
Yes,
You're there for a short time.
yes,
Then you go back to Portia's apartment.
correct.
Lamont, LaRon, and Jennifer are there.
Yes,
It's at that time when you go back that you see the victim's property?
yes,
Is that the first time you've seen the victim's property?
yes.
And you see it on Portia's bed?
Yeah, in the bedroom, the master bedroom.
Do you know who put it there?
No,
You and Jennifer went for a walk,
yeah, we went to the store up the road.
and approximately what time was that?
In the afternoon, maybe between 11 and 12, 1-ish, somewhere around there.
And it's at that point that you come into direct contact with law enforcement.
Yes,
Law enforcement wants to find out where LaRon is.
correct.
You don't tell them where LaRon is.
No,
You are ultimately taken to the police department, is that correct?
yes,
You don't know that the police have found LaRon and Lamont until after you're at the police station.
yeah, it was quite a while afterwards.
So you weren't there when they arrested them at apartment 7, which is Portia's apartment.
No, I was already taken away.
And you talked to law enforcement
Yes,
there at the station
yes.
with Detective Gibson?
I Don't remember names with faces, but
Okay.
I spoke to a few different detectives. and-
Fair enough. Did you give statements to two separate detectives?
I believe so.
I'd like to show you what's been entered into evidence at the State's Exhibit 8C. Do you recognize that photograph?
This is the first time I'm seeing it.
Okay, do you know who that is a
Yes.
photograph of? Can you tell the jurors, maybe I can turn this on. I might have to live with you, Jennifer, since see this. Is that a picture of Lamont?
Yeah, that's Lamont Newton.
And can you see any injuries on Lamont in that picture? No?
Not from here, no.
Can I bring the picture to you then?
No, not in the picture. You can't see.
And how about, who's this a picture of? This is State's Exhibit 8A.
That's LaRon Rayford.
And can you see any injuries in that picture on LaRon?
No, you can't see them on him.
What part of the body were the injuries on that you saw?
On LaRon, it was the bottom of his feet, and the both of them had marks on their elbows and their knees. Like the backs of the elbows and their knees. It looked like they were rolling around on.
Were they wearing shorts or jeans that night?
They were wearing jean shorts and maybe basketball. One of them might have been in basketball shorts, or I don't exactly remember to detail what they were wearing, but it was shorts.
You had been going with LaRon for several months?
Yeah, a few months.
And had you been living together that entire time?
Pretty much. I got an apartment down in St. Pete within dating him for maybe a week or two, and I got a place for us to be down there.
And were you in love with LaRon?
After a while, yes.
Were you faithful to LaRon?
Yes.
Was LaRon faithful to you?
Your Honor,
No.
I'm going to object as to relevancy.
I'll sustain that objection.
If I could have a moment, Judge.
Yes, ma'am.
Nothing further at this time.
Thank you. Redirect, Mr. Trevino?
Briefly, Your Honor. Again, Jennifer, this is not meant to embarrass you in any way, but it's an important question. You gave two separate statements to the police on October 24th, which would have been the day after this happened, correct?
Correct.
You have had your deposition taken, correct?
Meaning,
When we went to your apartment,
Yes.
and the court reporter and the lawyers and the state attorney, everyone was present?
yeah,
Okay. and then you have in court, during various motion hearings and such, have testified numerous times, correct?
Yes.
Hours and hours of testimony.
Yeah, it's,
Okay. Candidly admit that you have lied to the police in this.
I'm objecting. I say her characterization.
Why don't you approach the bench? Next question, Mr. Trevina.
Thank you, Judge. Ms. Chiron, you've given inconsistent statements in this case in the past.
yes.
If I may have a moment, Chiron?
Mm-hmm.
Oh, that's right. I'd like to have the transcript. Gotta remember, you talked to the boys here. Maybe we could do it through the rain. No further questions, Your Honor.
Thank you. Is this witness excused?
Yes, Judge. It's
Yes, Your Honor, she's excused.
All right. Ma'am, you're free to leave the building.
Okay. Is transportation going to be provided home too with the,
Do you have the return set up? We'll get with victim witness to arrange that.
Just wait outside, we'll make sure it gets taken care of. You're welcome. Okay, ladies and gentlemen, it's almost 12:30, so I'm going to go ahead and give you your lunch break. Please do not discuss the case among yourselves or with anyone else. Please don't look at any news media. Thank you very much for your patience with us this morning.
Your notepads on your chairs, please.
Here it is, right here.
Oh, an hour, sorry. The court reporter knew. I have my mind going too fast. Sorry, I apologize. 1:30.
I don't know what happened to the transcript.
The jury's out hearing in court.
Okay. All right, so let us have her come just back in the door. I want to make sure we've arranged for her trip home. Thought I just saw your face was no, you hadn't arranged for it. Let's bring her in, Mr. James. So we need to make, I mean, we can't leave this witness here without some transportation home. Obviously, the jury's not hearing this, but I want to make sure she is treated with the same respect as any other witness. So,
Oh, yeah. The problem, Judge, is we didn't know when she would be finished.
okay, well, you need to take care of it. All right, so, Ms. Chiron, I'm just trying to follow through to see that we make you get sure you get home safely. So, Mr. James, before you leave the room, let us make sure before you leave the room, we're going to all communicate together. All right, so, and that's your aunt with you, right? And I'm terrible with names, ma'am. I know you've been in here before and testified. Would you stand up for me, ma'am? What's your name, please?
Amy,
Okay, and how did you get here, Amy?
with her.
Okay, and so what kind of vehicle brought you?
It was a van, transport van.
Okay, and how did she get downstairs?
They carried her down.
Okay, so it is good when you arrange for the witness to come that way, to get them home that way. So Mr. James is going to assist you in getting that done. He works with Mr. Trevina. I am hopeful that that will be organized and set up over lunchtime. We're taking an hour lunch break. If there is a problem, please, ma'am, you let me know as soon as lunch is over, because we're not going to have you stuck at the courthouse, and we know that there are medical problems that you need to be able to be at your home for, okay? Thank you. All right, 1:30.
Your Honor,
Yes?
would it be possible to give us an extra 15 minutes over the lunch break? I anticipate resting, but I have some communications I need to deal with.
All right, I can give you till, be back 15 minutes already then, so please use it wisely.
I will, thank you.
Thank you. And so then everybody should be ready then to finish talking about Mr. Trevina. After that, how long were you thinking of? Unless the state, do you think you might be having some rebuttal?
Just possible, Judge.
All right, so, well, we'll deal with that after they rest. Okay. Well, if we can still get them, 1:45 is fine with me. If they're already,
It is too late for that.
that's right, so,
But for the rest
right. Well, I told the jurors 1:30. Now Mr. Trevina's asked for another 15 minutes, which I'll grant him, so I know they're going to be sitting there for 15 minutes, but since they've already been told 1:30, I don't think I can change that. So we will be back in here together at 1:45 to give Mr. Trevina the time he has asked for.
Okay,
Thank you.
Court is in recess till 1:30 according to the courtroom clock. No, 1:30 because we told them 1:30.
Okay.
But he wants 15 extra minutes. They're not supposed to. That's not
But either way, most of them are. Yeah, that's true. So I'm just gonna say to read this from Dale.
Can you lock the board
Use your
with,
time.
Barry?
But that's it, that's the only case.
Okay, sounds good, thank you.
Sorry?
He's going to talk to her about whether she's going to testify.
Yeah, and then actually, they'll hold you, I don't know if they'll go all at once.
I was thinking about it.
Oh, okay.
I wasn't sure what your,
Yeah, no, that's right.
okay.
Yeah, the job's just out.
Okay, we got to clear the courtroom.
I'm hoping, really. We just talked, yeah, and she's cool with it, so. Wait, going all or nothing, waiting. It's already done. Who has a draft of the jury instructions? Do you have those?
Yeah.
I want to go over those.
Sure. Got them right here.
I believe you also testified that prior to Jennifer leaving, she was talking or having conversations with another person on that phone.
Yes, she was on LaRon's phone, and she had received a phone call, and that's what prompted her to leave the apartment.
And they were gone approximately 10 to 15 minutes.
Yeah, not long at all.
And she came back upset.
Yes,
Then LaRon came back.
yes,
Then Lamont came back.
yes,
She said she heard gunshots.
yes,
And after all three of them came back, you wanted to go back to where this crime occurred.
correct.
You didn't know where it occurred.
No,
You hadn't been to that crime scene.
no,
And no one told you where it occurred.
no. I didn't know specifically where it was until I was released, and I actually seen the news set up there, and they were taping the crime scene. That's why I actually physically seen where this had took place.
Had you ever been in that crime scene before?
No,
Do you know where it is now?
yes.
Did you know it was behind a deserted house?
Well, I knew it was at a deserted house. I didn't find out it was behind the house for quite some time.
That was after the fact.
Yes.
So you'd never been back behind that house?
No, ma'am.
After they all get back, you all decide to leave the apartment.
Yes.
You change clothes?
At that time, yes, I changed into some, I was wearing a pretty short dress, and so I changed out of the dress into, I believe, a pair of pants or something, and grabbed up some clothes, yes.
And LaRon changed clothes?
Yes.
And Lamont and Jen went into the bathroom?
Yeah. There, we were in and out the bathroom. The boys were bleeding and stuff like that, so it was pretty chaotic. It was,
And you're not telling this jury that you poured bleach in that bathtub on those clothes, are you?
no.
Jennifer poured the bleach on the clothes.
I can't say that for 100% fact.
Jennifer and Lamont were in the bathroom.
Yeah,
You smelled a strong odor of bleach coming from that bathroom.
yes.
So Jennifer or Lamont poured bleach on the clothes.
LaRon was in the bathroom at some point, too. I can't,
But you didn't pour bleach on the
No.
clothes.
I may have come up with the idea, but
Just
physically.
listen, just ask my questions.
Your Honor, I would ask that the witness be permitted to respond in full.
My rule in here always is that a person can answer the question yes or no and give a very short explanation. Okay, next question, please.
The next day, you go back to work.
Yes,
You're there for a short time.
yes,
Then you go back to Portia's apartment.
correct.
Lamont, LaRon, and Jennifer are there.
Yes,
It's at that time when you go back that you see the victim's property?
yes,
Is that the first time you've seen the victim's property?
yes.
And you see it on Portia's bed?
Yeah, in the bedroom, the master bedroom.
Do you know who put it there?
No,
You and Jennifer went for a walk,
yeah, we went to the store up the road.
and approximately what time was that?
In the afternoon, maybe between 11 and 12, 1-ish, somewhere around there.
And it's at that point that you come into direct contact with law enforcement.
Yes,
Law enforcement wants to find out where LaRon is.
correct.
You don't tell them where LaRon is.
No,
You are ultimately taken to the police department, is that correct?
yes,
You don't know that the police have found LaRon and Lamont until after you're at the police station.
yeah, it was quite a while afterwards.
So you weren't there when they arrested them at apartment 7, which is Portia's apartment.
No, I was already taken away.
And you talked to law enforcement
Yes,
there at the station
yes.
with Detective Gibson?
I Don't remember names with faces, but I
Okay.
spoke to a few different detectives. and-
Fair enough. Did you give statements to two separate detectives?
I believe so.
I'd like to show you what's been entered into evidence at State's Exhibit 8C. Do you recognize that photograph?
This is the first time I'm seeing it.
Okay, do you know who that is
Yes.
a photograph of? Can you tell the jurors, maybe if we can turn this on? I might have to move you, Jennifer, and see this. Is that a picture of Lamont?
Yeah, that's Lamont Newton.
And can you see any injuries on Lamont in that picture? No?
Not from here, no.
Can I bring the picture to you then?
No, not in the picture. You can't see.
And how about, who's this a picture of? This is State's Exhibit 8A.
That's LaRon Rayford.
And do you see any injuries in that picture on LaRon?
No, you can't see them on him.
What part of the body were the injuries on that you saw?
On LaRon, it was the bottom of his feet, and like the both of them had marks on their elbows and their knees. Like the backs of the elbows and their knees. It looked like they were rolling around on.
Were they wearing shorts or jeans that night?
They were wearing jean shorts and maybe basketball. One of them might have been in basketball shorts, or I don't exactly remember to detail what they were wearing, but it was shorts.
You had been going with LaRon for several months,
Yeah, a few months.
and had you been living together that entire time?
Pretty much. I got an apartment down in St. Pete within dating him for maybe a week or two, and I got a place for us to be down there.
And were you in love with LaRon?
After a while, yes.
Were you faithful to LaRon?
Yes.
Was LaRon faithful to you?
Your Honor,
No.
I'm going to object as to relevancy.
I'll sustain that objection.
If I could have a moment, Judge.
Yes, ma'am.
Nothing further at this time.
Thank you. Redirect, Mr. Trevino?
Briefly, Your Honor. Again, Jennifer, this is not meant to embarrass you in any way, but it's an important question. You gave two separate statements to the police on October 24th, which would have been the day after this happened, correct?
Correct.
You have had your deposition taken, correct?
Meaning,
When we went to your apartment,
Yes.
and the court reporter and the lawyers and the state attorney, everyone was present?
yeah,
Okay. and then you have in court, during various motion hearings and such, have testified numerous times, correct?
Yes.
Hours and hours of testimony.
Yeah, it's,
Candidly admit that you have lied to the police in this.
I'm objecting. I say her characterization.
Why don't you approach the bench? Next question, Mr. Trevina.
Thank you, Judge. Ms. Chiron, you've given inconsistent statements in this case in the past.
yes.
If I may have a moment, Chiron?
Mm-hmm.
Oh, that's right. I'd like to have it transcribed. You talked to the boys here. That's good enough, 'cause I can't read it. Maybe we could do it through the rain. No further questions, Your Honor.
Thank you. Is this witness excused?
Yes, Judge. It's
Yes, Your Honor, she's excused.
All right. Ma'am, you're free to leave the building.
Okay. Is transportation going to be provided home too with the,
Do you have the return set up? We'll get with victim witness to arrange that.
Just wait outside, we'll make sure it gets taken care of. You're welcome. Okay, ladies and gentlemen, it's almost 12:30, so I'm going to go ahead and give you your lunch break. Please do not discuss the case among yourselves or with anyone else. Please don't look at any news media. Thank you very much for your patience with us this morning.
Your notepads on your chairs, please.
Here it is, right here.
Oh, an hour, sorry. The court reporter knew. I have my mind going too fast. Sorry, I apologize. 1:30.
I don't know what happened to the transcript.
The jury's out hearing in the court.
Okay. All right, so let us have her come just back in the door. I want to make sure we've arranged for her trip home. Thought I just saw your face was no, you hadn't arranged for it. Let's bring her in, Mr. James. So we need to make, I mean, we can't leave this witness here without some transportation home. Obviously, the jury's not hearing this, but I want to make sure she is treated with the same respect as any other witness. So,
Oh, yeah. The problem, Judge, is we didn't know when she would be finished.
okay, well, you need to take care of it. All right, so, Ms. Chiron, I'm just trying to follow through to see that we make you sure you get home safely. So, Mr. James, before you leave the room, let us make sure before you leave the room, we're going to all communicate together. All right, so, and that's your aunt with you, right? And I'm terrible with names, ma'am. I know you've been in here before and testified. Would you stand up for me, ma'am? What's your name, please?
Amy
Okay, and how did you get here, Amy?
with her.
Okay, and so what kind of vehicle brought you?
It was a van, transport van.
Okay, and how did she get downstairs?
They carried her down.
Okay, so it is good when you arrange for the witness to come that way, to get them home that way. So Mr. James is going to assist you in getting that done. He works with Mr. Trevina. I am hopeful that that will be organized and set up over lunchtime. We're taking an hour lunch break. If there is a problem, please, ma'am, you let me know as soon as lunch is over, because we're not going to have you stuck at the courthouse, and we know that there are medical problems that you need to be able to be at your home for, okay? Thank you. All right, 1:30.
Your Honor,
Yes?
would it be possible to give us an extra 15 minutes over the lunch break? I anticipate resting, but I have some communications I need to deal with.
All right, I can give you till, be back 15 minutes already then, so please use it wisely.
I will, thank you.
Thank you. And so then everybody should be ready then to finish talking about Mr. Trevina.
I'm sorry.
After that, unless the state, do you think you might be having some rebuttal?
Just possible, Judge.
All right, so, well, we'll deal with that after they rest. Okay.
Coming back at 1:30 or 1:45?
Well, if we can still get them, 1:45 is fine with me. If they're already,
It is too late for that.
that's right, so,
But for the record,
right. Well, I told the jurors 1:30. Now Mr. Trevina's asked for another 15 minutes, which I'll grant him, so I know they're going to be sitting there for 15 minutes, but since they've already been told 1:30, I don't think I can change that. So
All rise.
we will be back in here together at 1:45 to give Mr. Trevina the time he has asked for.
Okay, sir.
Thank you.
Court is in recess till 1:30 according to the courtroom clock. No, 1:30 because we told them 1:30. Okay. But he wants 15 minutes and then they're not supposed to. That's not her.
Most of them are.
Yeah, that's true. So I was gonna say too, after this from Dale.
Can you lock the door and very
But that's it, that's the only case. Okay, sounds good.
sorry?
He's going to talk to her about whether she's going to testify.
Yeah, actually, they'll hold you. I don't know if they'll go all at once.
I was thinking about a little.
We are, but
Yes.
got it.
It.
Oh, okay.
I wasn't sure what your,
Yeah, no, that's what I'm.
yeah.
Yeah, the job's just half.
Okay, we got to clear the courtroom.
I'm hoping really bad.
I went through the lessons.
We just talked, yeah, she's cool with it, so. Wait, going all or nothing, waiting. It's already done. Who has a draft of the jury instructions? Yeah. I want to go over those. Sure.